Namaste, good morning. Welcome to this 49th episode of AAA webinar series, which is done every Saturday at 11 a.m. And for the 49th week, we are continuously doing this. Thank you very much for joining, and thank you very much for encouraging us. Every time we conduct a webinar, we see that the participation is increasing. Today, we have our subject, which is very important, and also some judicial pronouncements have been done on this Section 29, capital A of the Insolvency and Bankruptcy Code, which was inserted later on, and it was not the original section in the code, but then it was inserted later on. So I still recall the kind of feedback which was going to government, that there may be criticism or there may be opposition from the politically opposition parties, that this law actually can be considered as a very big scam in case we say that the company has been taken over by somebody else and the promoters, the company, like scenario, like for example, any company, large company, in case it becomes a news item that the creditors have accepted a resolution plan with a haircut of 50%, and the company has been given to the same promoters for running. Now, in this case, in case the balance 50% is recovered from the promoters, then the promoters will be proceeded against. That will be a kind of complete contravention and a complete clash of interest. One side, we are trusting the same promoters for running the company, managing the company, and kind of repaying the dues of the creditors. And same way, in the same breath, we are saying that we are proceeding against the promoters, maybe under the insolvency law, individual insolvency law, or under any other section, including the criminal part of it. So therefore, it was immediately decided by the government that it has to be a very, very kind of a uncontroversial law, so that it doesn't go to the same promoters. So therefore, the Section 29A was promulgated. It was inserted in the Act. So Ankit, welcome. In fact, I just started it.
And I'm sorry I got a little late. So anyways, we can continue. Yes.
Very important today. I think you were also busy in one session on a webinar that you were doing.
Yes.
And today, in fact, for you and for me, both of us, this day is very busy. I have another participation as a speaker in a webinar which is organized by Institute of Company Secretaries of India. Then this Kerala Bar Association has also invited me as a speaker at 3 p.m. And then Gujarat National Law University has also invited me as a speaker, all on a video platform. And right from now till evening 5:30, I would be continuously on the webinars. And you have just finished one, Ankit. What was that?
This was with respect to the impact on the recent changes and the proposed changes on registered valuers.
Oh, great.
So basically, that was the idea, to share the recent updates. And there are a few disciplinary orders that have now come against registered valuers as well from IBBI. So that's something that we were all discussing about all this.
So I think we could start with our with sharing our screen, and we are still not sure whether this will become part one, whether we'll be able to finish in part one or part two. All depends upon the questions which we would like to answer. So Ankit, please keep seeing the questions in case you come across a question. So we'll start taking the questions.
We'll do that.
So the Section 29A is primarily a section which is considered to be an eligibility for a resolution applicant under a resolution process. A resolution applicant is a person who actually can submit a resolution plan for taking over the company and resolving the stress of the company. Section 29A was in fact inserted later on after it was inserted almost about 1 year after the promulgation of IBC in India. So we will cover these three main parts: importance of Section 29 capital A in CIRP and liquidation, process of verification under Section 29A, which Ankit actually will deal in detail because Ankit is also doing a verification under Section 29A for various insolvency professionals independently, and also the relevant judgments on this would also be discussed and deliberated today. So first of all, the importance of Section 29A is basically, it is a key provision in determining the eligibility of resolution applicants for submitting a resolution plan in the CIRP or corporate insolvency resolution process of a corporate debtor. So it is basically a multi-layered and comprehensive standard of disqualification where there are total 10 clauses, and all the clauses are in fact very, very important, and it defines the eligibility of resolution applicant. And this is where the government of India wanted that the promoters should actually not come and take over the company. Although there was a big discussion in the matter of Swiss ribbon by the Supreme Court, and it was argued the constitutional validity of the Section 29 capital A was also argued, and it was argued basis that there should be some difference between the tainted promoters, fraudulent promoters, or all those promoters who have suffered the market conditions and have incurred losses. So finally Supreme Court rejected this argument, and the 29A, capital A, was implemented. It was held as constitutionally valid, and it was held that the company cannot be given back to the same promoters even if they are involved into the fraudulent transactions or not involved. In fact, originally this section was not there. So before this insertion of this Section 29 capital A, every individual or a body corporate, every promoter, every director, every shareholder could have submitted a resolution plan for taking over their own company, which in fact was into stress. And for the same company, they were not able to run properly. For the same company, they were not able to pay the dues of the creditors, and therefore they defaulted. And the IBC law, when it was promulgated on 1st of December 2016, there was no such provisions that the promoters are debarred from taking over their own companies. So this was something which was a lacuna. It was very quickly, it was observed by government based on various feedback. So finally, it was inserted by way of an ordinance on 23rd of November 2017. 23rd of November 2017. So it was almost 11 months after the promulgation of the IBC, this was inserted. So this it was considered to be a very, very fatal loophole in the law, allowing the backdoor entry to the defaulting promoters. First, originally the ordinance was issued, and later on it was made as an Amendment Act 2018, and the Amendment Act was passed on 19th January 2018. However, the effectiveness of this particular provision, Section 29A, was from 23rd of November 2017. So the first amendment, the ordinance, as I said, it was effective from 23rd of August 2017. And there was in fact some more amendments were done. The definition of resolution applicant was also changed. Originally, the resolution applicant was only mean any person who submits a resolution plan to a resolution professional. But when the amendment took place, then the doors were open for even individually submitting or joint submission of a resolution plan. That was amended, and it was also amended that the resolution plan would be submitted. Post an invitation under section 25 clause H subsection 2. So originally section 25 to H was simply invite prospective lenders, investors, and other persons to put forward a resolution plan. But after this amendment, it was section 25 subsection 2 clause H was also amended, and it was substituted as the insolvency professional will only invite those resolution applicants who submit a plan, who fulfill certain criteria laid down by him with the approval of the committee of creditors and other conditions which may be specified by the Insolvency and Bankruptcy Code. So why I brought this section 25 subsection 2 clause H to this particular webinar today, because see, when this particular amendment came, so there were two eligibility criteria which is supposed to be specified by the committee of creditors in consultation with the resolution professional. One, that eligibility criteria about that may be the specific eligibility criteria which can be considered, which can be framed considering the value of the company, considering the size of the company, considering the kind of investor required, kind of resolution applicant required for such companies. So that is the basis that there are two kinds of eligibility tests now. One test is that regarding the committee of creditor will create some tests, and that can be some net worth criteria, that can be some criteria for having disposable liquid funds. The criteria can be having some kind of similar experience. The criteria can be having some kind of credit rating. The criteria can be some kind of experience in resolving or kind of reviving companies under stress. So these are many kind of eligibility criteria that can be stipulated by committee of creditors considering the total overall status of the company, the expected value to be realized, the kind of person, the kind of group it is required for revival. So, and the second eligibility criteria would be as provided in section 29 capital A. So there are two eligibility criteria now, and it has been held that a resolution professional is having the first responsibility to verify the eligibility criteria as approved by committee of creditors, and also the eligibility criteria under section 29 capital A. The primary duty to verify lies with the resolution professional. However, the committee of creditor will also approve a resolution plan if the resolution plan complies with the eligibility criteria. So the responsibility is almost joint. However, the primary responsibility of the resolution professional has already been held as primary, and the committee of creditors cannot absolve themselves by just saying that the RP verified. However, they also have to verify, they also have to see whether that kind of authentic verification has been done or not. This is what I could understand from some of the words used in the some of the judicial pronouncements. So going forward, we actually can say when the section 29 capital A was inserted, we could see there are 4 layers of ineligibility. 4 layers of ineligibility because there are 10 clauses, clause A to J. There are 10 clauses in section 29A, and all the 10 clauses are applicable to, number 1, first layer ineligibility, where the resolution applicant itself is ineligible. Any of the clause between A to J is applicable to resolution applicant itself. Second layer, the connected person to resolution applicant is ineligible. So there are some clauses which are not applicable to connected persons. There are some clauses which are applicable to connected persons also. So there is a third layer. Third layer is that is the related party of the connected persons of the resolution applicant also has to be qualified eligible. Then fourth layer is where a person is acting jointly in concert with a person suffering from first layer, second layer, third layer ineligibilities. So if there are some people who are working jointly and they're related parties, their connected persons, all of them has to be eligible under section 29A. That's a very, very complicated section, but it is something which can be understood. Like when we go forward, we can definitely say what are these clauses and how it is applicable. Now, when we see this section 29 capital A, it starts with a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person. Any other person acting jointly or in concert. No, acting jointly can be seen. However, in concert means it has to be somehow some order may be required that these are the people, they are actually acting in concert with someone. So then the eligibility criteria is applicable to the person and the joint applicant, and also to the person who is working in concert with the person or the joint person. Now coming to the first clause of section 29A, like this person, the RA or the connected person, RA or the connected person or the related parties it should be an undischarged insolvent. If it is an undischarged insolvent, then it becomes ineligible. Now, undischarged insolvent can be if a company is under CIRP, that means that company would not be eligible. If any individual is not, if any individual is not undischarged insolvent under the Companies Act or under the earlier presidential law or the other insolvency law regarding individuals, that also would be not eligible. So, Ankit, would you like to say anything about the undischarged insolvents?
So with respect to the undischarged insolvents, what happens is that in case of a company, the details are available on the IBBI website, whether that company is in any way an undischarged insolvent or not, because you can simply search on IBBI website and try and find out if the company is insolvent. The second source of information for an ongoing insolvency for a company, which is available today, is the MCA data. Because when we file INC 28, the status of the master data changes to under CIRP. So these are two stages through which we are able to get information on whether a company is an undischarged insolvent or not. However, with respect to a person, then we are mostly relying on a public search on Google or a search on the NCLT or the DRT database. But there again, it is sometimes difficult to find out if somebody is an undischarged insolvent in their personal capacity. Although practically, of course, the whole PG insolvency or the individual insolvency process is going through a difficult time, but still that information is not centrally available someplace today.
So for each clause, Ankit, you actually will guide the our viewers, like how would you verify such a clause for the RA, for their relatives, for their connected persons, for their subsidiary companies, for their holding companies, and their associate companies. So this is all that for every clause that you will do this exercise. And how would you verify? How would you use the information available on the public domain? How would you use this softwares that we are using? So the clause B is that the resolution applicant or the connected person or the relative should not be a willful defaulter under the guidelines of the Reserve Bank of India issued under the Banking Regulation Act. Now, there is a master circular, and Ankit, you can tell me better regarding the willful defaulter.
So with respect to the willful defaulters, what happens here is that there are lists of willful defaulters which are published or rather notified through circulars, various circulars by RBI. So what we have done internally is we have made a compendium or rather a common document of what is available on RBI's website. which becomes a searchable document then. And we simply search the name of the person who is either the RA or in any way a relative or a connected person. And when we search for that person and there is no result, we then kind of document that, yes, this is how we've tried and found out in case that person is a willful defaulter.
So willful defaulter is a process which actually is guided by the RBI circulars under the Banking Regulation Act. So any person, in case the bank is trying to declare him as willful defaulter, the bank will have to go through a process. And that process would be completely defined in the RBI circular. And it is also said that finally the the individual who actually is likely to become, who is proceeded for willful defaulter status, will have a personal hearing at least before the bank executive, not less than executive director. And if anyone has actually been adjudged as declared as willful defaulter without going through this process, there is a remedy available and immediately stay would be available from the courts. So the process, for the bank, it is very, very important to complete the process. And for the willful defaulter, it should not be accepted in case the process has not been completed by the bank officials as defined in the RBI circulars. Moving on to the third part, which is the clause C, and this is the most important clause, and which is say that at the time of submission of the resolution plan. Now, this is also been a dispute at what point of time the person should not be an NPA. Now, at the time of submission of a resolution plan, and it was substituted again, Second Amendment in 2018, at the time of a resolution plan, has an account, or because it is starting with the same language that the RA or the connected person or the relatives at the time of submission of a resolution plan has an account, or an account of the corporate debtor under the management or control of such person, or of whom such person is a promoter, is classified as NPA in accordance with the guidance of the RBI under the Banking Regulation Act, or the guidelines of a financial sector regulator issued under any other law for the time being in force, and at least a period of 1 year has lapsed from the date of such classification till the date of commencement of the corporate insolvency resolution process of the corporate debtor. So you see, there are disputes and there are judicial pronouncements on this particular clause. One judicial pronouncement is that at the NPA status, whether that status is there or not, that has to be seen at the time of submission of the resolution plan, not before and not later. So in case at the time of submission of resolution plan, there is no account which is NPA, then the person will become eligible. And in some cases, in fact, in the asset steel also, it was seen that the applicant is having that account which is NPA. Then it was actually held by the Supreme Court that in case we are giving a chance to the resolution applicant, that the resolution applicant can make the payment of overdue amount, convert that account into a standard account, and then submit a resolution plan again. So then it will be eligible. So the Supreme Court, in fact, took that lenient view that rather than rejecting a resolution plan, provided an opportunity to ArcelorMittal. And that's what is a very, very famous case. So therefore, at the time of submission of resolution plan, it should not be NPA. And at least 1 year has been lapsed. Now, there are some provisos to this clause, and which say that provided that the person shall be eligible to submit a resolution plan if such person makes the payment of all overdue amount with interest thereon and charges relating to non-performing assets account before submission of the resolution plan. So that's also very clear that in case before submission of resolution plan that account is settled, then this ineligibility under this clause would not be there. So there is a further proviso which says that nothing in this clause shall apply to a resolution applicant which is of where such applicant is a financial entity and is not a related party to the corporate debtor. Now, there are situations that the banks or financial institutions or NBFCs or they can actually finance a particular project in such a manner that actually can be converted into equity later on, or in case of default, it can be converted into debentures, or it can be converted into, again, some kind of preference shares. So in all those cases, it is not applicable to a financial entity if it is not a related party to the corporate debtor. I'm coming to these other clauses which says that there has to be a conversion of the debt. Now, in case we analyze this clause, which is clause C of the section 29A, then we can analyze in such a manner that at the time of submission of resolution plan under section 29A, debars a person or persons acting jointly or in concert with such person who has a classified account as NPA, who has an account classified as NPA. Secondly, is a promoter of a company, the account of which company has actually been classified as NPA. Third, is in the management of the corporate debtor, the account of which has been classified as the NPA. That means that he's a director. When we call it a promoter, that means that the substantial shareholder is in control of a corporate debtor, the account of which has been classified as NPA. So these are the subsections. Subsection means these are the subdivision of that section is the clause C. Again, one segregation in case of one slicing can be done, that the at least 1 year should have elapsed from the date of NPA till the insolvency commencement date. Therefore, any company, including the promoter's person in the management of the control of the company, which has its account classified as NPA for at least 1 year, will not be able to file a resolution plan. However, the code provides for a carve out that such person shall be eligible to submit a resolution plan if such person makes payment of all the overdue amounts. And then coming to the explanations. Then when we come to the explanations, these explanations are primarily that financial sector regulators, anything which is converted into substitution of debt into the equity shares or instruments convertible into equity shares, that we can understand that if any bank converts its debts into equity, that doesn't make that bank as a related party, because the banks will have a different kind of scenario. So these are the explanations, and the other part which is important is that this explanation 2 says that for the purpose of this clause, where a resolution applicant has an account or an account of the corporate debtor under the management or control classified as NPA, and such account was acquired pursuant to the resolution plan. So in case, like for example, Vedanta takes over a company under insolvency and starts the implementation. Now, if anyone will see that Vedanta has a company which was NPA, and therefore that particular thing is also excluded. However, that is restricted to 3 years. In case the company which is taken over by Vedanta continues to be NPA for next 3 years, then Vedanta would not be eligible under section 29A. So Ankit, before I move on to the D, how do you verify such things while you give a report on 29A eligibility?
So with respect to the NPA, the largest what we can sometimes ask for is the CIBIL report from the resolution applicant, and we then also sometimes ask for the CIBIL report of the promoters of the resolution applicant. The other sources of this information are because this NPA database, there is no one database to kind of find out that if there are any NPAs. Then we rely on these public databases, that is Karza and Probe 42, to understand if there is any litigation ongoing between the person and any bank, or is there any other such matter which might indicate that there might be an NPA. That is the way we are able to understand this. But there is no central database for an NPA which is available to us publicly. The only
Also,
source that is available then is CIBIL, where banks have, of course, a gateway to check it, but we will have to then rely on the CIBIL shared by the RA itself.
so also, Ankit, we also we try to take an
Sometimes we do also get credit ratings on Google. Credit ratings then can show a default rating sometimes. That is something which is available publicly. So we can always enter the name of the person along with the word credit rating, and find out if there is any credit rating publicly available for that entity, because all credit rating agencies are required to publish online publicly the ratings that they have given for various entities.
And also, Ankit, like we advise all our professional colleagues, insolvency professionals, that whenever they take documents from any prospective resolution applicant or prospective bidder, there should be a format for information that would be provided by the applicants, and that would include a declaration of their names of their connected persons, names of their connected companies, names of their relatives, and all that should be as an information, also as affidavit. And then we actually, in the detailed RFRP or in the detailed e-auction document, we have also built-in clauses that in case the declaration which has been given on an affidavit by the applicant or by the bidder, in case that turns out to be incorrect, then their earnest money deposit would be forfeited. So these are the clauses that we have built in our RFRP and also in the detailed e-auction document. So therefore, the information will come, authentic information will come from the resolution applicant and the bidders. Okay, now moving on to clause D, because we have to complete 10 such clauses, and then there are about more than 10 very, very important judicial pronouncements from Supreme Court and from NCLAT. And we are not even sure that we will be able to do it in one part, because we want to just discuss in depth. I think, Ankit, because at this particular time, there may be some queries, so we can take some question answers.
Yeah, there are about 12 questions. So let me ask the ones that seem to be relevant. So the first question is from Mr. Venkat. He's saying that, can the promoter of corporate debtor submit a resolution plan if the corporate debtor is an NPA of less than 1 year? So the answer to that should be yes.
Yes, the answer to that should be yes, the promoters can submit if the NPA is less than 1 year old.
Then we have
yes, they can submit.
Then the question from Heyman G is, a shareholder holding 2% shares in a listed company, now delisted, can he be considered as ineligible under section 29A?
The 29A means it undischarged insolvent, undischarged. No, 29A.
It's a shareholder.
Yeah. Which clause? Like they are saying that he's a shareholder of 2% of a company, and that particular company is NPA. Yeah. No, I don't think that he doesn't become a related party, because the 2% is along with 2%, he should be a director. If he's not a director, then he's not a related party. Then we have to go to section 5, subsection 24. That is the definition of related parties.
So he has to be a promoter or a director. It can't be because he owns 2% shareholding, right?
Yes. Then he has to be promoter and director. That means promoter and director. In case 2% shareholding, then he should also have a directorship.
Then Mr. Vedyanathan is saying, or rather commenting, that financial creditors, banks who trigger IBC can give the willful defaulters details as they have data. So I think the willful defaulter detail is available publicly. So therefore, passing this responsibility to the banks is something that we feel is not required. Rather, NPA point of view, they can always help and check internally. But then there again, they would only have data with respect to their own bank. They won't have data with respect to other banks' NPA. That would be the problem. So, Nageshwaran ji is asking, can we ask for a credit rating report from the individuals? In my opinion, yes. If it is required for 29A verification, we can always ask for credit rating reports. What is your opinion?
He's saying individuals.
Yeah.
I don't think there is any credit rating company in India which is actually giving a rating on the individuals.
I think he means CRISIL, CIBIL rating. He
CIBIL
messaged
rating,
credit rating.
CIBIL
CIBIL is
rating
some.
is not a credit rating. CIBIL is a information company.
Yeah, I got your point, but then I think it is about, he is asking about CIBIL report, perhaps.
Yeah,
so that
CIBIL
can be
report
okay.
is available, but the credit rating is not available. CIBIL-like companies, there are 4 or 5 such companies which are called financial information companies, and these are all licensed by Reserve Bank of India. And that is the reason that they are doing their business, because they are licensed by Reserve Bank of India. They can actually access the information which is available with others, which can impact the credit score of a particular person. Credit score is a different thing. Credit rating is a different thing.
Then Aniket ji is asking, please elaborate on the sections and case references where promoters can submit resolution plans where the case is an NPA and but they are still an MSME.
Yes, in MSME they can submit a resolution plan, because for MSME clause C and clause H are exempted, but still in case they are not eligible under any other clauses of section 29 capital A, then the promoters of MSME also would not be eligible under section 29A, because the exemption which has been given to MSME is only for clause C and clause H of 29A. Clause C talks about the NPA status of the account, and clause H talks about the guarantee given by the applicant, and that guarantee has been invoked and it remains unpaid. So in most of the MSME units, you would see that the guarantees have been given and the guarantees also have been invoked, but it remains unpaid. So therefore, these 2 clauses are exempted for MSME promoters.
Right. So I think the next question is, in case the promoter shareholder is not a director and neither a PG for debt availed by the company, whether the promoter shareholder be ineligible under section 29A in case the company is classified as an NPA. So promoter...
in case a person is considered as promoter, and maybe when the company was incorporated, maybe when he represented before the banks while taking the loan, maybe when the company was being run by the promoter, and
also now the declaration that who all are promoters is also part of the balance sheets, because this was an amendment that happened about 2 years back, where they realized that the disclosure that what is the shareholding of the promoter and what is the relationship of the promoter was missing. So that has been inserted now in all the MCA forms and the balance sheet formats, so that the company, when it is preparing the financial statements, is actually sharing that who all are the promoters. So it's already also part of the financial statements.
So okay, so and what any next question?
So if there is a consortium of banks and they have declared CD as NPA on different points of time, from when period of 1 year is recommended? The earliest period?
Earliest period.
Earliest period should be the answer to that question. Can a JV partner...
There is a judgment on this, that the date when the bank declared the account as NPA, that is the date, not the effective. Because see, there are cases where the bank declared the particular account
later, but it was actually, but it was not being serviced as per the RBI norms. It was earlier. So that is what you're saying.
Effective was much earlier. So the effective date is not really important. The date on which it is declared as classified as NPA, that is important. That is the date as per NCLAT judgment.
So can a JV partner who was an independent company, did projects in the past, is ineligible under Section 29A? JV partner. So so in case there is an entity or a JV which is not an NPA, but there is the entity with which the entity partners with for that JV, that entity becomes an NPA. In that case, there shouldn't be any 29A compliance issue here.
See, how come?
The JV, if the JV is not an NPA, that if the JV is NPA, then certainly there is a 29A issue.
NPA, then it will be ineligible.
Yeah, but if the entity with which one is a JV partner is defaulting independently, but the JV is still okay, then there shouldn't be any issue.
Yes, I believe so. But I don't think that in case a company is NPA, and if a company can create joint ventures, and those joint ventures would not be considered as tainted or as standard, because an NPA company promoting a joint venture, that also will be considered as ineligible as far as this Section 29A is considered. Yes.
Okay. Past director who was on the board 10 years back, whether he's ineligible, I don't think so. You can't go back to 10 years and say that somebody was a director then when the company was healthy and therefore there is a 29A compliance. I think the NPA has to happen.
As on the date of submission of resolution plan.
Yes. So I think we can continue and there will be other questions which we can take up later.
Okay, so we move on to clause D, where in case this resolution applicant or other connected persons, relatives, but that's what is the clause says, that has been convicted for any offense punishable with imprisonment for 2 years or more under any act specified under the 12th schedule. So this 12th schedule is given, and it's a lot of acts which are covered under this schedule, like this money laundering, PMLA means Foreign Exchange Management Act, pollution control norms, tax, income tax, anti-corruption, securities exchange market. So these are all the acts of Schedule 12, and there are many more acts where the conviction can happen. For 7 years or more, under any law for the time being in force. So this is also something which can be a very kind of dice, because how do you get the information about the conviction, Ankit?
Conviction is again something which is we're relying on those databases only, Karza and Google search, because there is no other way where you can find out if there is any punishment or any criminal act going on. The only source is these electronic databases like Karza, which give us information on the active cases in district courts, civil courts, as well as any other NCLT or DRT with respect to that person. But there again, the once we find out that there is a case showing up there, we have to go and check that exact case to find reference whether that person was the exact person against whom this case was going on. Because even there is no matching of the PAN or matching of any other unique number. So where the name matches, then we get a hint that there is a match in the name, but then the rest we will have to do, otherwise.
So I think the 2-year conviction is specified in the under all those acts which are covered in 12th schedule, and for 7 years and more under any other law for the time being. But there is a special provision, there is a special proviso that once this person is released from the imprisonment after 2 years, then this clause will not be applicable. So this is not forever. This is for only 2 years from the date when he is released from the imprisonment. And also there is a proviso which says that this particular clause shall not apply in relation to a connected person. So this is not actually this is not something which will be applicable to the connected person, because there can be many relatives, there can be many other people who actually can be convicted. So this is also one of the very important clause. Now going forward, this is the clause E, where the resolution applicant or in this particular clause also is disqualified to act as a director under the Companies Act. The proviso says that this clause shall not apply in relation to the connected persons referred to in clause 3 of explanation 1. So the connected person, this particular disqualification, in case there is a disqualification, that will not be applicable, because there may be many people who are disqualified under the Companies Act, even for smaller offense of not filing their compliances. Now, the Companies Act, in fact, defines what is a disqualification and who is a director who is disqualified. And there can be many such reasons. Like one can be the director is of unsound mind, director is insolvent, or his case is pending before the court on insolvency or unsound of mind, and then he shall have been sentenced for 6 months of imprisonment for an offense involving moral turpitude. An order has been passed by the court tribunal declaring him disqualified. He does not pay. He does not pay his calls on shares. He has been convicted of offenses dealing with the related party transactions under Section 188 of the Companies Act. He is prohibited from acquiring director identification number. So these are some of the disqualification. These are some of the reasons for disqualification. Ankit, I think there are some more reasons for disqualification, that if a person is not filing, if a company is not filing their returns for continuously 3 years, then the directors of that company also will become disqualified under Section 188 of the Companies Act. Is that correct?
Yes, that is correct. So that is again something which is...
How would you verify this?
So this is again something which is available on the MCA database. So the connected person, what they have done now is that they've connected the DINs with the PANs. So all the DIN database search can be done using the PAN number as well as the DIN director identification number. So one practice that we follow is that we ask the resolution applicant to also share the DIN wherever it is available for the persons which are connected persons and the CD and all that. So based on the DIN search, we are able to find the status of the director's DIN. If the DIN says it is active and compliant, then we are good. But if the DIN says that DIN search says that the director is disqualified, then then we can flag and kind of capture.
Okay. So normally we are able to get this kind of information.
Yeah. So DIN, but then the question here is that if somebody does not mention the DIN, or somebody says that I don't have this person's PAN number, in that case, then it is only possible through a search of the name and not through this process. So that is a difficult process wherever the DIN and the PAN are not available.
So that means when we take the information from resolution applicants or bidders, we should ask for the names and the PAN number also.
Yeah, so one of the formats that we have, we say that whoever are the connected persons, we don't need the copy of the PAN card for all the people. But we need the DIN number and the PAN number. And in case you're not providing it, then maybe a declaration that the people for whom the DIN and the PAN are not being provided do not have that DIN or PAN.
Okay, great. So moving forward to clause F, that particular RA or the connected person should not be prohibited by SEBI, Securities and Exchange Board of India, from trading in securities or accessing the securities market. So there are regulations 3 and 4 of SEBI, prohibition of fraudulent and unfair trade practices relating to securities market regulations 2003. And when we see these regulations 3 and 4, there are many such scenarios where the SEBI can prohibit a person under these regulations from trading in securities or accessing the securities market. And you probably see that there is a list of people like this. Every person is prohibited to buy. So this is the clause where, Ankit, how would you verify this clause?
So again, a little difficult, but then one has to make this database based on SEBI orders that are available on SEBI website. And then there is this BSE database, which kind of talks about this updated list of debarred entities. So now this is on BSE website, and one can download this file, which lists down, gives you in Excel the complete list of debarred entities by SEBI.
Okay, so that's also done. So we move on to clause G, which is a clause which says that has been a promoter, or I would say director, means the management or control of a corporate debtor in which. So if he has been a promoter or a director in which preferential transactions under section 43 of IBC, undervalued transactions under section 45 or 49 of the IBC, extortionate credit transactions under section 50 of the IBC, fraudulent transactions under section 66 of the IBC has taken place, and in respect of which an order has been made by the adjudicating authority under the code. It is only adjudicating authority. If that particular order is in appeal, still that person will become ineligible to take over a company. That's what is very clear here. And there is a proviso that this clause shall not apply if transaction has taken place prior to the acquisition of the corporate debtor by the resolution applicant. So this is not applicable to those promoters who have taken over a company, who have acquired a company through a resolution process under insolvency. So this is the this is something which we actually have to verify from the various companies which are under various companies where that particular resolution applicant or a connected person would have been a director or shareholder. And if any of those companies are under insolvency, then the third thing that we will verify is that in case in any of these companies, any order has been passed under section 43, 45, 49, 50, or 66 by adjudicating authority. So these are the kind of verification which is required for the clause G. Moving on to clause H. This particular clause is also exempted for MSME corporate debtors. In case a resolution applicant or connected persons or relatives has executed a guarantee in favor of a creditor and in respect of the corporate debtor against which an application for IBC insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. So there is some certain clarity that I want to give, that in case there is a guarantee and then the guarantee has been executed, the guarantee has been invoked and it still remains unpaid, but the company is not under IBC, technically this clause is not applicable in those cases. It is only applicable to those cases where that particular company is under IBC in CIRP or in liquidation. So this clause, where it is exempted to MSME, so there is a judgment also in this case, RBL Bank Limited versus MBL Infrastructure Limited, relevant to this clause H of section 29A. So this also we will take up when we go to the judicial pronouncements. So then we have this clause I. We have seen A, B, C, D, E, F, G, H, I. Now this I is basically a applicability of all the clauses from A to H, and that those clauses are subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. So this particular clause says that all the disabilities which are mentioned in clauses A to H and any kind of jurisdiction is not important. Even if these disabilities are in India or these disabilities are under any jurisdiction outside India, the clause I actually makes that person as disqualified under section 29A, even if he is debarred from a regulator regulating the securities market overseas, then it will be again ineligible in case he's been convicted for a sentence of 2 years or 7 years. Again, he would be ineligible. It doesn't matter whether this particular clause, this particular offense is in India or outside India. And then we are now coming to the connected person, which is the most controversial part of this section, connected person. The clause J says, has a connected person not eligible under clauses A to I. Has a connected person not eligible under A to I. A person who is connected to the persons defined under the explanation shall be disqualified if the other person suffers disability under clauses A to I of section 29A. Now the connected persons has been defined. Connected person has been defined by way of an explanation. Clause 3 of the explanation says that for the purpose of this clause, the expression connected person means any person who is the promoter or in the management or control of the resolution applicant. Any person who is the promoter or director. I would say any person who is the promoter or director of the RA is a connected person. So first of all, let's say the RA is A. So the promoter of A and the directors of A is also connected person. Then going forward, any person who shall be the promoter or in the management or control of the company after the implementation, during the implementation, like whenever we submit a resolution plan, we always see that who would be the director in the company and who would hold the shares in the company. So therefore, when we approve a resolution plan, we always insist that we need to understand who would be the director and who would be the shareholders of this company during implementation of the resolution plan. So, but then this clause is not applicable once the implementation is complete. Therefore, any proposed director or the proposed shareholder, they also should be eligible under section 29A. Then the third is the holding company, subsidiary company, associate company, or a related party of a person referred to in clause 1 and 2. Now, this is something which is the most important part. Most important part means this is most crucial, where in fact when we say that related party. Now, like the resolution applicant, for example, the resolution applicant is Mukesh Ambani. And Mukesh Ambani has a relative who is Anil Ambani. Anil Ambani is not eligible under clause C of section 29A. So therefore, Mukesh Ambani also would not become eligible to take over any company. Mukesh Ambani will also not be eligible to take over any company under the IBC. However, the Supreme Court has held in the case of Swiss Ribbon that in case a relative is not eligible under section 29A, but they are not doing business with the RA, then they are eligible. So that means if the Anil Ambani and the Mukesh Ambani are not doing business together, then they are eligible. In case they are doing business together, then they are not eligible. So Ankit, what is the now scenario? Because since we have now gone through the provisions of the law, and the clauses are still further we have to define, but we can see in case there are questions, or the definition, like as I said, that we have already analyzed this definition. So we actually can say that let's understand about the questions that we have now.
So the question, Ravi ji is asking a question. He's saying that NCLT is also rejecting plan even if PUF filed and not yet adjudicated on the ground that 29A compliance is not there for the resolution resolution applicant. I think we can share this order. Maybe this is a one-off order that has done this, but I don't think the interpretation of 29A says that any under adjudication avoidance transaction will also cause the failure of the 29A compliance or resolution applicant.
Yes, you're right. Yes, you're right. Because see, any such order doesn't make the law. The law is very clear that it has to be ineligible only after an order is passed by the adjudicating authority.
Then, if there is a question from RP Gupta ji, he's asking if the CD is not registered as MSME before the commencement of CIRP, whether RP may register the CD as MSME. No, that's not something that is appreciated by anyone.
That is, it is no. I think this is appreciated. There are some couple of judgments.
Okay.
There are a couple of judgments which says that in case the promoter is registering the company as MSME, because the promoter doesn't have any authority after the CIRP commenced. So there was a case where the promoter registered itself as registered the company without even giving any information to the RP. And the promoter was unauthorized to do this. So that was rejected. However, if the RP registers it as MSME, then it will definitely have the benefit of exemption, which is provided in the law under section 240 capital A, where clause C and clause H are exempted to MSME corporate debtors. So this is important that the RP can register the company during CIRP, because the RP cannot do something which is unauthorized, because in case the company is eligible to be registered as MSME, it can be registered. That's only a compliance. It has to be done.
Yeah. Another question is that if the promoter of a CD, which is an MSME company, if that promoter loses or is a disqualified director, will there be an exemption because he's an MSME? The company is an MSME?
No, sorry. Can you come again?
If the promoter of a company is a disqualified director, he can't be a director because he's disqualified as a director, but he is a promoter of that CD. So in that process, if the CD is an MSME, then the question is that will that MSME based exemption be available for disqualified directors? I don't think, right? That's yeah. So I think there are a few questions on the Mukesh Ambani and the Anil Ambani connection. I think we can deal with it next time. We are already 5 minutes up. And we can take other questions in the next session as well.
So we'll take down these questions and we'll take up. So what we are now going to do, that there's a lot more substantial information is available, like how to verify the 29 verification and all kinds of judicial pronouncements that will come as part 2 of this same subject. Because see, we wanted to deal with this subject very carefully. So it is very important. There are a lot of confusions. So along with the judicial pronouncements, along with the verification processes that we follow, so that all may follow. This is important that we should not hurry up. So therefore, we decide to do it in 2 parts. And in the next part, we will do the judicial pronouncements and the process of verification. I hope this webinar would have been useful to all of you, and we are definitely again excited about the increasing number of participation in our webinars. So Ankit, should we conclude it?
Yep.
Thank you,
participants. So thank you everyone.